Peace, we live. Welcome tonight, Advocates for Justice Paralegal School. We provide the tools and you do the work. You guys know how that goes, right? Welcome to the stream tonight. You guys, if you're coming from Facebook, please go to the address on the banner scrolling underneath me here and grant StreamYard permission to use your Facebook name. Otherwise, you show up as Facebook user when you post a comment. So go there and grant StreamYard permission to use your Facebook name. I think you only have to do it one time, and then you're good. All right, Coach Neighbors, we're going to get started here in a second. So the attorneys who refuse to walk away from the people using my packages are using the failure to state a claim for the reason why they're failing to go sit their butt down, like the other attorneys. So, so we're going to perfect stating the claim for relief just like they do. We're going to do it just like they want it. You know, when I first started doing this, I refused to do stuff their way and do what they want. I just refused to. And we had obviously pretty good luck with that. But, you know, every once in a while we have, well, for me, my goal is to set this program up so there's no court. Yeah, we want them to go sit down and shut the hell up. So I can say that, right? Yes, I can say sit down and shut the hell up, as long as I don't say nothing about, you know, where my legal team is good over there. That's who I'm talking to over there in the corner. When I look over there, I'm looking at them making faces. But we're here to get it done tonight. So let's roll. Failure to state a claim. That's what they use all the time. So I'm like, you know what? Yeah, so I've been studying this for a couple of weeks, a little longer, as you guys know, this failure to state a claim for relief, because I want to teach you guys how to get it done, because that's what the paralegal school is all about. Now, for you folks who already have invested in a lawsuit package, pay close attention so you can learn how to state a claim the way they want it. So you need to learn how to pay attention so that you can figure out how to do this. Because here's the deal: in stating a claim the way they want, you have to incorporate the facts of your situation. I did not say case, okay? Because you never want to go into court and start talking about all of the lies that they want you to talk about, okay? When you start your conversation with them, if you're using my products, then your conversation with them is going to start at the time addressing the lack of jurisdiction at the gate. You're addressing the lack of court jurisdiction at the gate because there's no injured party. There's no legal affidavit. The only affidavit that they have in some cases is an affidavit that the attorney reviewed the records. Okay, so you're getting sued by the records. I don't know how. Yeah, so yeah. Welcome, Neville. Welcome to the show tonight. We're rolling, and it's hot in the kitchen. Yeah, because when we get done learning how to do this, I can't wait to see what excuse they are going to try and come up with next to get out of being held liable for the fraud that they're doing. So you guys had already invested in a package. I don't want you guys to be contacting me, telling me you want the updated package and none of that. You have to learn how to do this. And I have several videos that outline this. Tonight, we're going to talk about this. I was going to talk about how to state damages, but I think I'm going to wait and do that next week maybe, because it got a little involved. Now, I've never had them move to dismiss because we didn't do a good job of stating damages, but we're going to do it like they want it done. So that's what we're about to do up in here. And my sister I sent her a couple of links on, so she could learn how to state a claim, or learn how to state damages. And oh, holy, she did a great job. When I was reading her thing, I wanted to just rule in her favor. Okay? Not because she's my sister. Okay, no, not because she's my sister. Oh, she wrote it. And so we're actually going to use what she put together in the package. Now, that's something that I'll be glad to provide you guys who are interested in that. You can send me an email and just put in it damages in the subject title, and then I'll email it over to you, and you can add it to your lawsuit if you're working on it already. And I'll actually show it next week when I cover that subject. So if you need that, now just send me an email and let me know. Send me an email if you've invested in one of my packages and you need that. So I just want I just want to be clear. Now you guys must make these changes yourself and add the facts about how the court proceeded without jurisdiction and how the attorneys are in here with all. What you need to do is incorporate the facts in your lawsuit into your claim. You need to incorporate the facts from the lawsuit and not all of this garbage that they want to talk about. So I'm hoping people get, because if you could come with the most badass fire document that you can get, but if you put their crap in it, you're going to open up the door to arguing, and then their buddy judge is going to get to help them. That's how their program rolls. It didn't take me too long to figure that out. Now, you must stick with the court violations of your due process, because that's what's going on here. You can argue case law and argue the lender, the servicer, all of that crap all day long. What is killing us is the fact that the court is violating your due process, and at the end of them doing that, everybody's running over there to appeal. Well, if you have to appeal, you should be suing somebody. I'm just saying. If you have to appeal, you should be suing somebody. So everybody runs over to appeal because that's what the conventional program that they structured has set up for you. If you don't like how bad they screwed you over, go over there and appeal to my buddies in the appellate court. Because I'm sure they're all buddies, and you know they are. And that's why people tell me I filed an appeal. People get into my program and then they want to connect with their appeal. No, dude, all of that stuff you were doing is worthless. So if you're going to get your lawsuit filed in federal court or use the lawsuit to file in the state court process to stop it and then file you, why mess around with their appeal? And I like to keep it simple. The reason your appeal is a piece of crap and it's not going to help you is because you're sitting around waiting for the judge to make a decision for you. You think the judge is going to help you? The other judges didn't. And if the judge does help you, all they're going to do is remand it back to state court so they can get your butt whooped the right way the second time around. If I'm off base, somebody let me know. Because I've been seeing this happen. You never, ever talk about the lender or their conventional lies in your document or in the phone conversations. Oh yeah, they really tried to get you to do that in the Zoom hearing. They try to get you to talk about the payments, and if they can get you to talk about the payments, you're already admitting that there was a loan. So you want to make them talk about what you need to talk about. That's how this works. You want to make them not want to argue. That's how we do it. You do not want them to have an opportunity to argue. And at the end of the day, you're going after people who signed. Now I have people call me or email me or message me or all of the above sometimes. And they're like, well, there's no signature. It's just a law firm. Well, so if it's just a law firm, then you need to look at the sign on the law firm and use the first name that's on the sign on the law firm. That's the person that you need to have for a defendant. I mean, it's pretty much cut and dry. Or I had a person call to let me know that that an employee from the trustee signed the documents to start the foreclosure, signed the notice of default letter. And I started laughing. And then she kind of said, "Oh, well, yeah, you're right. I see what you're saying." No, it was an employee that worked for the law firm. People, these corporations do a charge off. By the time your stuff goes into the foreclosure process, then it's done been charged off, it's done been written off, taxes written off, and claimed on insurance, and then illegally sold as a third party debt. And then I say illegally sold is because anybody that has any knowledge of the accounting, the GAAP accounting principles would know that after the charge off, there's no place left for additional income to show. So where's that? Oh, wait, that would be, if you were doing that, would be money laundering and wire fraud and a whole bunch of fancy ass. Yeah, I'm sure you guys get what I'm saying. So the lender don't have nothing. Now, I will say this. In the non-judicial foreclosure process, when you're served the notice of default letter, if you grab that 42 USC 1983 lawsuit or the other, any of the lawsuit packages and jam, then you can jam the lender up then. Because technically, the lender's still in there if they haven't got around to selling your house. So you see what I'm saying? Technically, the lender's still in there responsible if they haven't got the process set up and got your house sold. So in that case, it's a good idea to include the lender, even though you know the lender did this other process right over here, but they're stalling to give these fools time to finish wiping yours. Yeah, you know. All right, easy. I don't like it when I use the word wipe. I don't know what I would say next after wipe. Okay, I'm trying to be nice because if I start getting out of line, then I have to pay them more. Maybe they'll just do a citizens. Okay, never mind. Easy. So now add the state to the claim and to the top of the lawsuit list. And you never want to argue, and you add the state to the claim, especially if you use 42 USC and you're adding the state to the claim because the state is the one that is stealing, that has, okay, easy. The state is the one that is in control of your property deed and using it illegally. Okay, I'm good, I think. So, and think about it. The state is the one that's paying all of these sub-agencies, these sub-corporations to attack you and get in your face and beat you down. All of them, the county court recorders, the county with the tax, all of those people, they're all paid by the state. And the state is the one that has your original property deed. And the state law says that it's supposed to be delivered to you. But they do what the attorneys, when I say they, I'm talking about they do what they call their constructive delivery, and they're registered in their office. And they don't realize, or people don't realize that the very first illegal lien that was put against their property was the mortgage lien. And I'll be like, oh, well, dude, think about it. Like I said, I box and I play football in college, and I like to keep things simple. So the fact, if there were several people that own property, in order for a lien to be put against that property, a mortgage lien or any kind of a lien, all of the owners would have to be present to sign, right? So the fact that the alleged lender accepted your signature on the promissory note it proves that you were the owner of the property for a very short period of time. So I know that's the way until they prove me different, that's what I'm going to say. Legal team. Oh, sorry. Always start from the court's lack of jurisdiction, because that's what this is the court does not have jurisdiction. There's no injured party, there's no damaged property, there's no original contract, there's no accounting of the other money trail, there's nothing except a bunch of bar members getting each other's back. That's all you got, and lying. Keep it at the gate. keep it at the gate with the court's lack of jurisdiction. And when they move forward, then, well, do you got to the judge? Or if there's a court hearing already, then I would automatically go after the judge, because the judge has got no business looking at the case if the stuff's not there to give the court jurisdiction. I just keep it simple. Hey, Dylan, welcome to the show tonight. Well, you can say that, but I can't say it that way. Yes, you can. How's that? I can agree to that. I just can't say it. So tonight we're going to talk about this situation. I had a team member message me about the changes, and she needed to be breathing in the bag for maybe a day before she messaged me. And she saw the new videos about stating the claim for relief, and she just got her lawsuit package, and she just filed it her day, a little while before she called me, and she was freaking out because of the changes. And she's like, "Well, now I'm going to have to do this, and I'm going to have to do that." So, so I told her, it's like, look, it's probably not a good idea to contact me when you're maxed out like this, and you should be breathing in that paper bag. Okay, I'm just saying. And at the end of the day, in my offense, because I don't believe in being on defense, so in my offense, I told her that she didn't have to make the changes. Okay. I mean, it's true. You don't have to make the changes. But then I mentioned to her that they're going to complain about stuff. And if they complain about it, then that's when, well, actually what you should be doing is learning it and putting the changes together already and getting it ready to go. So that when they come up with this nonsense, you can copy and paste it in there and file it the next day. Blow their head right open. Oh, how did she come up with all this in like one day? Are you kidding me right now? That's how we do it. Now, I reminded her that there was a point when I was putting these packages together several years ago. There was a point in the non-judicial foreclosure defense package. There was a point in time where I had to make like 5 changes in a 2-week period. So this lady's getting off. She's getting off easy. I had to make 5 changes in a 2-week period. Now, I remind people that these changes that we're making we're making because we're learning. We're learning the fraud from all of the people collective that give me feedback, real-time feedback on how they're trying to escape the liability. We learn to make changes and do what needs to be done. So that's that's why we call it paralegal school. We're learning all the time. So if you come here thinking that everything is going to be normal, I'm just going to fill these out and just stick them in there without even watching an instructional video, because I'm going to use this as it was a conventional program when it's a non-conventional program. And when you do that, you're going to get yourself jammed up. And while you're trying to file your stuff, they're going to tell you that you're crazy and they don't know where you got this stuff from. They're going to tell you all kind of stuff. Now, if you watch the instructional video, then you'll know exactly what you need to say to them when they start talking nonsense. And that's one of the reasons why it's so important to watch the instructional video before you start doing all of this, so that you'll have an idea what's going on when they try to stick the little crap in your face. Because I already know about the little crap, and I mentioned about it in the instructional videos. Now, I want you guys to remember the instructional videos are in the instructional video playlist on my YouTube channel. You have to go to the YouTube channel and you have to search for the instructional video playlist. Or you can go to the website that's flashing across the bottom of the screen there, And I put a link that fades into the picture about 10 seconds after you click on the website. And that link takes you to the instructional video playlist. But you may well learn how to go find it, because you're going to need to be able to do that and look at the other videos and figure out what other videos you need to be watching that pertain to your stuff. I want you to remember, the instructional videos are in the instructional video playlist. Say it with me, everybody. Okay, sorry. The instructional videos are in the instructional video playlist. All of the other 290 some videos are not instructional videos. Those are training videos. Those training videos are mainly for people who've been doing this for a minute and already got themselves past the instructional video playlist to see the instructional video, because you can't use all of this stuff over here if you haven't done this yet. You got to get the foundation done with the instructional video and get your stuff filed, do all of that stuff. And then you can do the other things, work into what you need. You can't watch an instructional video and 6 other videos and then try to run everything together and be all crazy, and then you'll be breathing in the bag. That's what happens. And then when you contact me, you're going to get yelled at. So I'll blow the whistle in your face. Well, not in your face, because I don't want it to bend over. Okay, never mind. The other videos are training videos. People are thinking, okay, I'm watching the instructional video and then just watching the first video that pops up. No, the instructional videos are in the instructional video playlist. So I hope that we get that, because it's important to understand that. So when you call me and you say, I watched an instructional video, and then you ask me a question that's in the instructional video, I'm going to say, that question was covered in the instruction video. What video did you watch? From there, it usually goes in the toilet. Okay. I put the instructional videos together for people to watch, so I don't have to tell everyone everything all of the time. Because you guys can see my phone rings a lot. A lot of people have this problem, and we're just now figuring out how to get people to us so people can see what we got going on here. And so you guys need to remember, the most important thing is my paralegal school will be making changes as we learn. So, and now, that's not to say that it's not going to work for you, what you got or whatever, running around being crazy about it. We're making changes as we learn. Now, I'm thinking that's a better program to be in than just file this paperwork and go sit down and wait without making changes and adjusting the strategies based on what's happening to other people ahead of you in line. You see how that goes. But anybody who don't want to add the new stuff, you don't have to. I'm saying you don't have to add if you don't want to. Then we make changes because we're figuring out better ways. We're figuring out better ways. I can't say punch, so sorry, I didn't. We're figuring out better ways to counter their fraudulent system. How's that? Now, most folks have no idea how long it would take you to learn what you have access to here. With my experiences and my work with the Facebook groups and all of the people and my coaching. And my coach, Denny Harden, he was the one that helped me get started on learning how this fraudulent banking system works. And he posts in the group sometimes. He likes to kind of keep a low profile, but if he ever offers information to you guys in the group, you should take it and go check it out, because we're definitely on the same page. And he's one of the very few people that I allow to help guide us in the group. Now, like I said, we're continually learning, and we're not conventional. So I'm not going to always have an answer for you. And my promise is to make sure that you have an opportunity to fight, that you have an opportunity to stay in your house. Now, I'm not going to always have the answer for you, and I'm not going to make it easy for you. So now I'm not going to go on my way to make it tough either, but I have people calling me, hey, can you send me the link to know you? Go find it. Thank you. I'm busy. at the end of the day, if you don't go do stuff, you're going to always be asking for things to be done. And I'm not pointing a finger at anybody in particular. I'm a coach. And you're not going to learn anything if I'm making it easy for you. And I actually tell people that sometimes, and sometimes they get mad. I don't care. I mean, it's true. You want to learn how to do this. If you're not doing what I think, if you're not in the place where I think you need to be, I'm going to say something. Because the last thing I want is for people to be dragging their feet thinking that they're doing a great job and have me not say anything to them about the fact that they're not doing a damn great job. And then later on, they'll be saying, oh, coach, I did everything that you said. No, you didn't. And most of the time when this conversation comes up is the judge wasn't added and sued in the state court level. That's usually the problem that we're talking about when this comes up. But I want you to make sure you know that. When people call me, well, I filed everything, but I don't know. Look, I never promised you, we're fighting fraud. Okay. What I do promise you is that you'll get a chance to fight and you'll get a chance to, to slap some people in the face. I didn't say punch. Okay, I can't say slap either. You'll get a chance to make some people not want to take you to court. That's what we're going to say. Now, I'm going to post this link again. I'm going to share the screen and we're going to talk about the complaint. And we're going to share the screen so that you guys can follow along. I found this PDF and it's like really nice write up on it. I used it when I redone my sister's lawsuit and to answer to the attorneys for stating the claim. She filed it Saturday and they responded today, but I haven't had a chance to look at it. So I know we plucked the nerve if they respond in like, because they're always asking for a continuance. And we jammed them up pretty good. We added the RICO to my sister's lawsuit, and we also added the attorney that was representing the other attorney in their law firm in federal court, and neither one of the attorneys have passed the federal bar. So none of them have any standing to be representing anybody. And so then we also filed a notice for claim for the 1942 U.S.C. 1993 civil rights lawsuit against the clerk and the federal court because they're allowing these fools to file stuff and keep on going, doing all this stuff when neither one of them have a license or passed a federal bar to be in federal court. So we gave them our 30-day countdown so that by the time they get around to making their decisions, then we'll have our paperwork already ready to file a lawsuit against federal court. Because here's the thing. If you let them violate you with the court process and procedures, you might as well just pack your shit. I'm just saying. Because that's what this is about. They're violating you with the court procedures and processes, and people are letting them get, and then they run over to appeals court to go appeal. You're kidding me right now. Some people are figuring it out. So, JM, we're not here to answer your questions. You can ask me those questions in an email or whatever. We're here to learn tonight on stating a claim. This is something that everybody is using. Everybody needs to learn because they're using my product. So or maybe we'll answer your question. You can ask it at the end of our thing here. Maybe I'll take a look at it then. But I like to stay focused on what we're doing, and your question is not even related to what we're talking about. So, well, they can call it whatever they want, John. And I'm assuming you're right. I never heard that, and the reason they're doing that, in my opinion, is because they have a couple of sets of rules. There are a couple of sets of rules. There are the Federal Rules of Civil Procedure, which is the rules that everybody's supposed to be following. And then there is the local rules that they put together for them to follow because it allows them to speed things up and get more stuff done so they can make more money. And I'm not an attorney or a bar member, so I'm not obligated to follow none of their rules that aren't in line with the Constitution, their local rules. So that's how I roll on that. So let's just move on here so we can get to oh yeah, I was going to give you guys the link here. I need to go ahead and do that. Here's the link that we're going to be using. So if you want to just pull it up and follow it on your computer, or you can, I'm also going to do a screen share here in a second. Yeah, I think the attorneys got pretty maxed out when we went in there with the RICO stuff. So, because that's what they're doing. Okay, we're going to do a screen share here. Well, let me get the right link in here. And then we'll move it down here. Now, this is a nice resource. And anytime you're using these resources like this, you need to keep in mind that they're structured for attorneys. So, some of the things they're saying here are stupid and we would we would never do. But there is a wealth of information here. Hey, Wildfire Penny, welcome to the show tonight. So we're going to scroll down here and let me take a look at this real quick. We're going to take a look at the complaint list, and we're just going to talk about some of the things that you need to be aware of. So, how to draft a well-pleaded complaint. And you'll see that this is when I structured my sister's amended complaint. I just pulled this up. I actually made a checklist so I can make it bigger because these words are real small. And I put it in Word. I also saved it in Word, so if this website goes down, I still have the notes. And I put the notes up, and then I just followed along with this while I wrote out the story of what happened from, well, not from the lender or whatever. Remember, we don't want to go, in our case, it was from the fact that the court didn't have jurisdiction in the beginning because the attorney did not even file the affidavit stating that they reviewed the records. There was no affidavit filed in my sister's foreclosure case. So we're like, we don't know who's trying to steal our house. We think it's the attorneys because they're the only one that signed. Welcome, Edith. So we think it's the attorney because they're the only one that signed, and that's why we added them as the number one defendant or number two defendant underneath the state. So you guys can see here, this just walks you right through the steps, the things that you have to, and then here's a checklist. Now, I don't worry so much about the state rules because whenever I structure a document that's going to be filed in state court, I use federal case law. They hate it. They whine about it, but there's nothing they can do about it because there's no difference between doing that than there is between using Supreme Court case law and state or federal. You can use the higher court case law in the lower court. You can't go the other way. So if you're thinking like I think, that's going to create a problem when they respond to your law, whatever you file in state court, because your federal court case law stuff is automatically going to trump them. Yeah. There's a lot of little things like that that you'll learn working in our program where you're using the attorney's crap to throw right back in their face. There, I didn't say anything about punching. So, and you can see here, you have to adhere to the following things. Draft an effective complaint. Don't use fancy words. I don't use fancy words. Now, complying with the relevant federal and state laws and local rules. I don't worry about the state. I comply with the local rules. I comply with the federal rules of civil procedure and the Constitution. Constitution first, then the federal rules of civil procedure. That's pretty much it for me. And before researching, you don't have to worry about this because we're doing it now for you. I mean, the document's already got everything in that you need, except, and I have people have used it and have great, and are still in their house without stating the claim for relief the way they want it done. But you know what? I like making people give up. So to make them give up, you have to run their plays in their face. Okay, that's good. I can say that. You have to run their plays in their face. And that's what we're learning how to do here. We're going to learn how to run their plays in their face. Now, one of the most important things is subject matter jurisdiction. And for me, I put together, and I'll probably share that with you guys too, my subject matter jurisdiction. So they keep messing with us, and then it's making us have to step up. So I'm fine with that. As a matter of fact, I see it as a challenge. So we stepped up, and the main reason why state court does not have subject matter, the main reason why federal court has jurisdiction is because you're suing the state court judge, state, the attorneys that's licensed by the state, supposedly. That's a lie, but we'll use it when we need to in our favor. So you're suing them. And, you know, like I said, I play football and I box. Those are things that not smart people do. So I have to keep everything simple. You're suing the state, the judge, the attorney. And so the state has your original deed and it's holding it hostage and charging you property tax and all this other stuff and allow them to put a lien against your property. So the state is doing all of that. So the state court judge is paid by the state. You guys follow where I'm going with this? So if the state court judge is paid by the state, and the state is the one in control of your property deed because they violated the real estate deed, they're performing real estate defraud, they're in violation of real estate defraud. That's what they done because the state law, remember we talked about that, says that deed's supposed to be delivered to your house, to you, to the owner, and it's not. They commandeered it, and here's the kicker. And somebody tell me if I'm wrong here, because I throw this right out there on the table. Here's the kicker. There is no law or statute or code or anything that says that you have to register your deed in their damn office. So if there's no law that says you have to do that, you should be able to formally request to have your stuff delivered to your house as mandated by the state law and removed, your property information removed from their computer without even having to sue them with my child property tax lawsuit package. See, I worked the plug in there for that. But, you know, people come and ask me, oh, well, when you use that, I mean, at the end of the day, it's against the law for them to do what they're doing. So, so the jurisdiction issue, you know, the state is the one that's in control of your property deed through, they committed a real estate deed fraud. the state is paying the judge to help get your butt off their damn property. Can I say that? That's. I don't think anybody out there is going to argue with me on that. So that's why federal court is the only court that you have to go to because of what's going on over there. So, and you can use a few facts out of the document to support your jurisdiction. I mean, the other thing is, what you're going after them for is federal, they violate your constitutional rights or, Fair Debt Collection Act practice and all that stuff. RICO, oh yeah, we added that in. That's what plucked the nerve with them, RICO. Now, one other thing I want to share with you guys, a great source to get information from is Scrib, SCRIDB, Scrib. I use that website all the time. You can go there and you can look up documents for just like whatever it is that you're trying to do. You can look up documents that people have posted on there from your state. So you can have everything that you need. You can get the wording from them, the idea, see what they talked about, and then talk about that in yours. I mean, it's pretty simple. That's a great resource that you guys should be using. Now, this part is pretty cool here. This talks you through how to state a claim, and it kind of gives you how to get started. And so when you look at the context of what you're going to talk about, when I say what you're going to talk about, the lack of jurisdiction or whatever, and then you need to put it together kind of like this, and then line it out in individual paragraphs. Well, actually, what I did was I put it all out and then told the story. And then I went in and made it. Now, this is supposed to be a short and plain and simple. I don't really give a crap about short. It's more important to me to get the facts in there that you need so that when it goes to the next step, then you can demand discovery or whatever if it gets to that step. But that's how we do this. And this kind of walks you through lets you know what you need to be talking about. And then this shows you how to write it out. Factual allegations. And this is real cool because this, allows you to write it up and use things like use some of the words out of here to make it look like your attorney did it. And then here it tells you to draft separate accounts for each claim. And I looked at one lawsuit that I got off of Scrib, and that lawsuit, the attorney that wrote it up, he did his demand for judgment after each count, which to me is a little redundant, but they only need to see the demand for judgment one time, in my opinion. And then this is his second count. So you want to go through and do the same thing. Now, the way they had you do this is once you number all of when you make your story, and then you number your story in sentences, then you can go in and incorporate, from 1 through 49 was fraud, was the misconduct, violation of the Fair Debt Collection Act or whatever, or 1 through 62, which is all of them were violations of your due process. And so it allows you to number all of the stuff and then put the different numbers in the counts. And then here's some other tips. And you want to be specific about the relief you're asking for. And we'll go over that relief in the next video when we talk about how the best way to state your damages. And then the conclusion, if you adhere to these tips, you will ensure that your complaint is drafted in a concise, simple, and easy, readable manner, and set forth the required components: subject matter jurisdiction, relevant facts, meritorious legal claims, and damages to survive a motion to dismiss. So after studying this article, you should be able to put this together and have it done so that you're staying a claim the way they want to, so they can't come in and say you failed to state a claim. And I think it came out really cool. Now, what I would do, what you do here when you do this process, what I would do is add it to the front, the top of what you got already. So I would add it to the first, what this new stuff I would make on the front so they can read it right off the bat. And then the stuff that's already in their lawsuit package, I would just leave in there. Because you can't never have you want them to see what you're going to be bringing to the table. All you got to do is get past this first hump, and you're going to be bringing this stuff to the table, and it's going to be a problem for them because they can't defend it. They can't come up with any of the documentation that they need to prove that they made you a loan because they didn't make you a loan. Matter of fact, I've got a couple of new people in the group and have one doctor that called me today, and he was sharing a little bit of information. This guy helps people in all different states stay in their house also, and sometimes he buys the notes to so that the bank can't foreclose on them and stuff. But he was telling me that when the bank processes the Federal Reserve, your stuff and through the Federal Reserve, they're granted anywhere from 10 to 100 times the amount every 3 months or every 90 days, every 3 months. So and he's like, they don't need to foreclose because they're getting so much money, but they're just greedy. So it's going to be interesting. I'll get to learn more from him. I'm looking forward to helping him get some things done. He invested in one of the lawsuit packages, and I think he's going to go and take a look at the online course. Now, I have an online course set up now for both judicial and non-judicial. The non-judicial page is not showing yet. I still got a few things to do, but the online course, if you go to teachable.com or click on the link to go to my Teachable site, you can see both courses are there. And they're set up and ready to go. I have, I think, 72 people in the non-judicial and the judicial course, and maybe 14 in the non-judicial course. The non-judicial course is pretty new, so those courses are on the website, and the website's been reworked and got some new things on it. So if you guys haven't been on the website, you should go and check it out. Now, next week, I'm going to go over the damages and how to state that. If you guys have any questions that you'd like me to touch on next week about what we talked about today, if you email them over to me, I'll review them, and then maybe we can figure something out. So John here has another question. The attorney filed an affidavit to jurisdictional challenge 14 months after I filed the summary judgment, and I sued the judge in state court. Now the attorney filed a summary judgment and notice of sale. So, John, this is, I don't know anything about your case other than what you just wrote on the screen here. So there's no way that I'm not sure what it is that you want, because I don't tell people what to do. I'm not sure if you asked me what to do here. I'm pretty sure in my instruction video, I have it lined out, what you're supposed to be doing. And I refer people back to the instruction video because I don't remember when I put the instruction video together. I've been studying everything that I have in there for like several days. And then, 2 or 3 or 4 years pass. And so people call and ask me, well, I don't remember everything that's right off, and if I tell you and I miss something, then, he doesn't tell you. So I just send you back the instruction video. Now, if you go to instruction video, you say, hey, I watched this in instruction video and I have a question about that or whatever, then I can work it out. Because now we have a place to start. And I know you have some kind of idea. Otherwise, I have to start from square one. When people don't watch the instructional video, then, I have to spend way too much time. And then I've already been through all this. It never works out. So Uh, and John, if you want to discuss this further, if you have watched the instruction video and you have a question about the instruction video directions and your situation, I'll be glad to, you can just send me an email and I'll be glad to respond to you. JM had a question. What does the law or legal say about being too late to do anything if the foreclosure auction sale was 2 years ago, also with a default summons? So, JM, I think I can answer your question. So, what you're asking me here is it too late to step up to go after them for stealing your property? So, I think that's what you're asking me. And so that's what I'm going to answer. And the answer is, oh, hell no, it's not too late. You can challenge jurisdiction up to 15 years. And I have that in the documents, the case law for that in the documents. You can challenge jurisdiction for fraud for longer than that. And there's other ways you can go in for breach of contract. I mean, there's so many ways to get your foot back in the door. So no, you have to remember that what you're going to learn here is non-conventional. So, and we don't have any limits short of us not being able to file in court. we don't have a bunch of limits following all of the things that you're thinking about. You have to remember, if you're in this program, it's non-conventional. So you just need to go and rock and roll. And then when they try to put up a block, we'll figure it out. That's how we roll. So no, it's not too late, especially if you go in with the 42 USC 1983 Civil Rights Lawsuit package, then you're going to be good to go, because that package addresses the fraud, it addresses the lies, it addresses the court misconduct, the court problems, the issues with the court that violates the court process, that violates your right to due process. So you can bring that anytime. And when you get the right people on there, you make a nice splash. Now that package is on my website that I put on the screen, winningcourtnow.com. So you guys can go there and get that package. It's on sale right now for half price, $600. Okay, so if you guys have any questions about what we talked about today for next week, email them to me and I'll add them in. And thank you guys for the privilege of sharing your time. And I think this is going to be powerful. I didn't say badass. I said powerful. This is going to be powerful when we start doing this to add to what we already got on the table. So I'm excited about this, and I'm trying to make this available for everybody to learn, because in this school, you got to learn how to do it yourself. And that's what we're teaching you. You don't have a chance unless you learn how to do it yourself. So thank you guys. I'll see you guys in the next stream. Have a great evening.